amended, which the clerk will report by title.
Union Calendar number 96, H.R. 1275, a bill to direct the exchange of certain land in Grand, San Juan, and Uinta counties, Utah, and for other purposes.
The question is, will the House suspend the rules and pass the bill as amended? So many that are in favor say aye. Those opposed, no. In the opinion of the chair, 2/3 being in the affirmative, the rules are suspended.
Mr. Speaker, on that, I ask for a recorded vote.
A recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having risen, a recorded vote is ordered. Members will record their votes by electronic device. This will be a 5-minute vote.
Check, check. Check, check, 1, 2. Check, check. Check, 1, 2, 3. Check, check.
analysis at any of our hearings.
In one place. I just kind of go where I want to go.
Yes, quite the keepsake, aren't they?
Do you have information on how this man died, Doctor?
Yes. We took the liberty of imaging the corpse.
No.
Bedazzling premiere.
To their trophy.
No.
I decided to put my perfumes into matching
collection. Exquisite scents.
Every 2 years.
Especially people over 60.
Here's a cappuccino.
You might have glaucoma.
Who rules the world?
800 of the skin.
Plan plus A1C
All across America right now.
Being in the affirmative, the rules are suspended. The bill is passed.
Ms. Slaughter votes aye. Tender. Mr. Alexander votes aye. Mrs. Napolitano. Mrs. Napolitano votes aye. Reservation in the state of California to provide a water supply for domestic, municipal, industrial, and agricultural purposes and for other purposes.
The question is, will the House suspend the rules and pass the bill? As many in favor say aye, those opposed say no.
Mr. Speaker, I ask for a recorded vote.
The recorded vote is requested. Those favoring the recorded vote will rise. Sufficient number having risen, the recorded vote is ordered. Members will record their votes by electronic device. This will be a 5-minute vote.
The last vote in this round, this bill concerning a water project study on the Tule River Indian Reservation in California. Today in the Senate, members continuing consideration of Homeland Security Department spending for the next fiscal year. You can watch that live on C-SPAN 2. And the Senate Health Committee continuing its markup of health care legislation today. We're covering that live on C-SPAN 3. Here on C-SPAN, next the House moves on to debate the Small Business Research Programs bill, and later the House plans to take up the Agriculture Spending Bill. A Capitol Hill reporter is here to tell us more about that. The House resumes work on fiscal 2010 spending with a bill to fund agriculture programs. Paul Krozak of Congressional Quarterly on the phone with us. What are the key issues we're likely to hear in debate?
Well, I'm not sure this is going to be a really contentious debate. There wasn't much debate on this bill in the House committee markup. There are 13 amendments that will be allowed, and some of those amendments would move money around within the bill. One of the amendments would cut the spending by 5%. That's very unlikely to pass. And there are a number of amendments that would eliminate earmarks. Some of those may pass and others may not. It's hard to say.
Now, on the House floor, are we going to see some of the same kind of protests from Republicans that we saw on the first couple of spending bills that came up before the July break?
I expect we will. I mean, so far, all of these appropriations bills that have gone before the House have had structured rules which limit the number of amendments and limit debate. And Republicans have pretty much, protested that rule each time through various parliamentary maneuvers and delaying tactics. And I think Republicans are still putting together their strategy for this bill, but I would expect protests.
Have the Democrats answered their concerns, and if so, how have they done so?
They really haven't. No, I mean the Democrats would like to get these bills through quickly. I mean, the traditional appropriations process is that you have opportunity for unlimited amendments on the floor, and then when the consideration of the bill starts getting too long, then the two sides work out an agreement to limit amendments, but you don't start out with a limit on amendments. So, I mean, Republicans continue to insist that it should be an open rule with unlimited amendments, and Democrats are limiting the amendments, and so there's really no progress forward on that.
Lawmakers in the Senate Appropriations Committee approved their version of the bill yesterday. How's that bill the same or different from the one we'll see in the House?
The bill is similar. Probably the key issue is that the House bill prohibits any poultry imports from China. It continues an existing prohibition that has been in the Agriculture Appropriations Bill for the past few years. The Senate bill has different language, which was put in yesterday, which would repeal that prohibition if certain conditions are met, including more stringent inspections of Chinese poultry processing plants by the Department of Agriculture and so on. So when the House bill is passed, later when the Senate bill is passed, when they come to conference, that will be a key issue. And I would not be surprised if a compromise were worked out that would allow poultry imports from China.
Paul Krozak of Congressional Quarterly, thanks for the update on the agriculture spending bill.
Thank you.
On this vote, yeas are 417, nays are 3, 2/3 being in the affirmative. The rules are suspended. The bill is passed, and without objection, the motion to reconsider is laid on the table. Where is she? For what purpose is General Lady from New York rise? I better get some order.
Okay, Mike.
House will come to order. I think, is Ross going to... Please remove conversations from the floor. House will come to order. For what purpose is General Lady from New York rise?
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days to revise and extend their remarks and include extraneous material on the bill under consideration.
Without objection, so ordered. Pursuant to House Resolution 610 and Rule 18, the Chair declares the House in the Committee of the Whole House on the State of the Union for consideration of H.R. 2965. The Chair appoints a gentleman from Arkansas, Mr. Ross, to preside over Committee of the Whole.
The committee will be in order. The committee is in the Committee of the Whole House on the State of the Union for the consideration of H.R. 2965, which the clerk will report by title.
A bill to amend the Small Business Act with respect to the Small Business Innovation Research Program and the Small Business Technology Transfer Program and for other purposes.
Pursuant to the rule, the bill is considered read the first time. General debate shall not exceed 1 hour, with 40 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Small Business, and 20 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Science and Technology. The gentlewoman from New York, Ms. Velasquez, and the gentleman from Missouri, Mr. Graves, each will control 20 minutes. The gentleman from Tennessee, Mr. Gordon, and the gentleman from Texas, Mr. Hall, each will control 10 minutes. The chair recognizes the gentlewoman from New York.
Thank you, Mr. Chairman. I rise in support of H.R. 2965, updating and enhancing the Small Business Administration's Small Business Innovation Research and Small Business Technology Transfer Programs. Mr. Chairman, I yield myself as much time as I may consume.
Recognized.
I rise in support of H.R. 2965, which will reauthorize and improve the SBA's SBIR and STTR programs. This bill has strong bipartisan support and will work to invest in entrepreneurial innovation and job growth. While our economy is recovering, it still has a ways to go. Even now, we need to be focused on putting Americans back to work. We need growth that is lasting and industries that are sustainable. We need jobs that cannot be shipped overseas and will not evaporate in the next cycle of boom and bust. But those jobs aren't going to appear out of thin air. They need to be created. By expanding existing industries and unlocking new ones, H.R. 2965 will generate the jobs we need. The SBIR and STTR programs are vital to small business growth. Year after year, they help jumpstart 1,500 new companies. At the very least, that is 1,500 new employers. Over time, that is millions and millions of direct and indirect positions. But while these initiatives are crucial, they are not living up to their full potential. Through H.R. 2965, we can improve SBIR and STTR so they are running at maximum capacity. Job creation, Mr. Chairman, is the primary goal of R&D. But in order to generate new positions, we have to first develop new industries. Commercialization is critical to that process. But unfortunately, most research never makes it to the market. To address that issue, we are creating commercialization benchmarks. We are also encouraging conversations between SBIR officers and purchasing agencies. Ultimately, those dialogues will enhance the flow of information between buyers and sellers, helping more ideas from the drawing board to the marketplace. When all is said and done, commercialization means more than new products. It means new jobs. Once a product hits the mainstream, it opens up a world of opportunity in a wide range of industries, from retail to manufacturing. By stimulating these sectors, we can help our economy on its route to recovery. Even as our economy rebounds, small firms struggle to find funding, particularly equity investment. Just a year ago, venture capital firms drove $5.7 billion into small companies. Today, we have seen almost a 50% decline. In terms of what that means for the economy, there are now $3.7 billion fewer dollars to help our small businesses create jobs. The program's current regulations only compound those challenges. By shutting venture capital out of SBIR and STTR, we are blocking billions of dollars to create jobs and limiting our ability to innovate. What are we supposed to say to a venture-backed firm that is researching cures for pancreatic cancer? Are we supposed to shake our heads and say, sorry, you have done some promising research, but we just can't help you find a cure? Mr. Chairman, this program is better than that. That is why H.R. 2965 gives small firms, not Washington bureaucrats, the final say in how their firms are financed. This bill provides for the reasonable use of venture capital while maintaining important safeguards. Make no mistake, SBIR and STTR are and forever will be small business programs. This provision doesn't change that. What it does do is give small firms the funding they need to develop new products. Even with the necessary capital, small firms struggle to see R&D from start to finish. That is because it is a complex process. Measures to block funding delays and increase efficiency will streamline R&D, helping more products make it out of the laboratory and into the marketplace. Meanwhile, we're going to broaden the scope of American invention. Silicon Valley doesn't hold a franchise on innovation, which is why H.R. 2965 reaches out to underserved rural areas. Through cutting-edge technology and grassroots marketing, it also seeks to bring women, minorities, and veterans into the SBIR and STTR programs. Innovation is the first stop on the path to prosperity. By enhancing and expanding SBIR and STTR, we can encourage small business growth in all parts of the country. In doing so, we will help our small firms to grow, innovate, and most importantly, create homegrown jobs. Mr. Chairman, I reserve the balance of my time.
Gentleman from Texas.
Missouri.
I'm sorry, the gentleman from Missouri.
It's okay, Mr. Speaker. Mr. Speaker, I yield myself such time as I may consume.
The gentleman from Missouri is recognized.
Mr. Speaker, I rise in support of H.R. 2965, the Enhancing Small Business Research and Innovation Act of 2009. Innovation happens every day. Whether it is a new development in the fight for cancer or a new computer system designed to protect our soldiers, more and more good ideas are coming from America's small businesses. The Small Business Innovative Research, the SBIR, and the Small Business Technology Transport, the STTR, programs help to take ideas and turn them into practical products. By all accounts, the SBIR and STTR programs are highly successful federal initiatives designed to encourage economic growth and innovation within the small business community. Created in 1982, the SBIR program offers competition-based awards to stimulate technological innovation among small private sector businesses while providing government agencies with new cost-effective solutions to meet their needs. This program is not only critical to the unique needs of each of the participating federal agencies, but also to our national economy. Small businesses invigorate the U.S. economy by introducing new products and lower-cost methods of doing business, sometimes with substantial economic benefits. They play a key role in introducing new technologies to the market, often responding quickly to new market opportunities. Our committee worked in a bipartisan manner to produce this legislation. We held several hearings on this topic over the last few months, inviting the Small Business Administration, SBR and STTR program managers from federal agencies, various small businesses, academics to discuss the program's successes and to consider amendments that would improve them. I'm happy to say that many of the ideas that were presented to the committee have found their way into this legislation. For example, the topic that dominated much of the discussion at our hearings was the appropriate level of venture capital involvement in the SBIR program. Unfortunately, there have been several misconceptions stated about this provision in the bill. In 2003, the Small Business Administration reversed a 20-year-old policy by ruling that small businesses that are majority-owned by venture capital companies can no longer compete for grants under the SBIR program, regardless of how few employees the companies have. As a result, this has jeopardized the development of innovative treatments, therapies, and technologies. The goal of our proposal is to ensure that America's small businesses continue to be the world's leader in innovative research and development and to provide the best small companies with the greatest commercialization potential access to SBIR and STTR programs. In addition, access to capital is a real concern for small businesses across all industries, and our provision provides small businesses another path to acquire the capital they need to be successful. It is also important to keep in mind that these programs will remain open for competition among all small businesses, and that federal agencies will choose the best small business to win the award. H.R. 2965.
The subcommittee will reconvene. The chair recognizes the fact that there might be members of the subcommittee who did not have an opportunity to ask questions of our witnesses in before we recess. However, the chair is very cognizant of the witnesses' time and will take this time to go into a second round of questioning. And if there are members who come in who have not asked questions in the first round, then the chair will prolong their questioning for us to 7 minutes. So with that, the chair recognizes himself for 5 minutes for 2 minutes of additional questioning. In his white paper describing the proposed regulatory reform, the Department of Treasury stated clearly that, and I quote it, the FTC should retain authority for dealing with fraud in the financial marketplace, end of quote. Despite this assurance, the proposed language appears to weaken FTC's authority in this area. FTC would retain the authority to enforce against unfair and deceptive acts and practices using the FTC Act. However, the FTC could not add any statutory claims such as the Truth in Lending Act or the Equal Credit Opportunity Act to a complaint without first referring the case to the new agency and waiting 120 days for the agency to decide if it wants to take the case. Chairman Leibowitz, let me ask you, how will this change impact the FTC's ability to pursue financial fraud? Could the FTC pursue one part of a case while the other is under consideration at CEPA? Or would you expect that it would simply not bother with additional claims? Will FTC's cases be weakened if they only rely on FTC Act claims?
Well, I think think I'll go back to this mic. I think, Mr. Chairman, that's a great question, and keeping in mind that we're at the beginning of the legislative process, not near the end of the legislative process, those are questions I think that this committee will want to think through as the legislation proceeds forward. Last week, we brought a bunch of cases which we called Operation Shortchange, and it was about scams that were hitting people in economic distress, and a lot of those were basically fraud claims under the FTC Act. But one of them involved the Electronic Funds Transfer Act under and Reg, I think it's Reg E. Now, Reg E would go to the new agency, and so this would sort of invoke two parts of your question, or two components to your question. One of which is, would we have to wait 120 days to bring this case while there's ongoing harm? And then the second issue is really, what is the nature of our backup authority? And I want to say, Mr. Barr and I have been working through this with our staffs, and very, very productively. You know, I worked on the Hill for 13 years, and I never wrote a piece of legislation, or for my bosses then, that didn't change as it went forward. But I think these are precisely the questions that we worry about at the FTC. We want to make sure, and I know Mr. Barr does too, that this legislation is as effective as it can be for the consumers that all of us represent. And so I think it's important that you focus on this.
Well, it seems that if the FTC, the consumers would benefit more if the FTC didn't have to solely rely on the so-called backdrop authority. Do you agree with that?
Well, again, I mean, from my perspective, and I'll turn the mic over to Mr. Barr in a second. But from our perspective, if the backup authority is weak, and we have backup authority involving the SEC and the CFTC, which we use very rarely, only when we need it. But here, sort of a couple of points. One is, as the transition is happening, if this legislation is created, you want, and certainly even after very good lawyers are transferred and attorneys and jurisdiction, it's going to take a while for this new agency, as Mr. Barr knows better than anyone, to ramp up. And I believe that they're going to want us involved using our backup authority probably more earlier than later. Now, we understand that they will be they'll have primary jurisdiction here, but I think it's very important that the backup authority be robust so that we can sort of help out, and also so that when we have these cases that involve malefactors that don't fit into the old or new silos, that we can effectively go forward and stop ongoing harm involving consumers.
Yeah, before you, Mr. Barr, and the chair is really cognizant of the fact that his time is almost up. We'll give the ranking member whatever time he may consume. But I have just one question. Earlier you stated that you had lost some personnel. Is these the individuals that was transferred to Treasury?
We have
we have and if these are the same individuals,
we have one or two people who've gone over.
And what is the purpose of them going over to Treasury?
I'm sorry. What
is their purpose for going over to Treasury? Are they transferred? Are they on loan to Treasury, or are they reassigned to Treasury?
Oh, I think they're on detail to.
They're on detail to Treasury. What's the purpose of them being on detail to Treasury?
What does that mean?
What is the purpose of them being on detail to Treasury? What are they doing over there?
I think they're. Well, I'll turn that over to Mr. Barr. But I do know that the one person I know who is on detail to Treasury is a fabulous attorney and really cares about consumer protection and also the FTC.
All right, well, once you turn it over to Mr. Barr, now let him answer the question. Thank you. Mr. Barr, would you begin your answer with that last question, and then you can respond to the other questions?
Sure, and then I'd be happy to address the broader points. We have on our staff a terrific attorney from the FTC who's come over on detail and is going to be a permanent employee of the Treasury Department working on consumer issues. With respect to the broader sets of questions, I would just say, first and foremost, the chairman and I have been working closely together, committed to working closely together on these sets of issues. On financial fraud, it's clear from the President's proposal that it would not in any way diminish the FTC's ability to take on financial fraud cases, as is stated in the white paper and in the legislation. The FTC would retain its authority and its duty to bring financial fraud cases without delay. With respect to coordination, there are many issues that the agencies will want to coordinate on. The 120-day measure is not like the existing authorities that the FTC uses, where it's the primary entity doing enforcement. This is a proposal that kicks in. If the FTC is doing its work and finds a problem, it can let the new agency know, the consumer agency, know about it. It doesn't have to wait, as the FTC does today. It doesn't wait until it's gone through its investigation, gone through the whole charging process and gotten it all ready, and then refer to the Justice Department. It's totally unlike that. This is a chance for the FTC to let the new agency know about a problem that it sees that's come to its attention. So it's a fundamentally different mechanism. We're committed to being sure that that in no way delays any financial fraud cases. And with respect to the transition issues, again, the FTC and the bank agencies will have large transition issues. We're committed to working those through. And as I mentioned to Representative Schakowsky, Treasury is responsible for ensuring that transition happens smoothly, and you can hold us accountable for that.
With that, the Chairman, my time is concluded. Now, Mr. Donovan is recognized.
Thanks, Mr. Chairman, and welcome back. Mr. Lieberman, Leibowitz, excuse me. Uncertainty is one of the key factors behind the perpetuation of our current economic crisis, and granting a new and unknown regulatory agency with this broad scope of power could place a dangerous level of uncertainty into the financial markets. Do you think that it might be better to have an experienced regulator such as the FTC with a long and trusted history of working with business at the helm with these new powers?
Well, as you know, I'm very fond of the Federal Trade Commission, as you are. I would say this. You know, as you know, I testified here a few months ago that we thought we could do the consumer protection mission involving predatory financial instruments. The proposal that has been developed, though, is one that is broader than that. It has bank examiner components. It has compliance proponents. So those are not things in our core competency. You know, again, we're a creature of Congress. We're an independent agency, and so we will do whatever you tell us we're going to do, and then beyond that, I would say this. I just want to come back to my initial point, which is based on what we've seen in this marketplace and the restrictions that we've operated under. I do think that with these issues worked through, and I believe they will be, I do think that having this new agency and the FTC both going after unfairness, deception, fraud is considerably preferable to the status quo.
And we agree on that. I mean, I think the issue is how you go about it. I will say, though, that meeting with the bankers in my district back home, they're afraid of this, and I think that's the uncertainty question is a legitimate question. And
well,
if it does bring the specter of increased regulatory management over the industry, not that something has to be done in order to get to correct the mistakes of the last year, but you know, what's it going to do to the industry's willingness to get out there and unfreeze liquidity like we're all wanting to? I'm happy if you want to respond.
If I could just add to Chairman Leibowitz's comment on that, I think that A key new factor is this agency would have all the supervisory and examination authority it needs, not just with respect to banks, but also with respect to non-bank competitors of those banks. So I understand that many banks are worried about the scope of the new Consumer Financial Protection Agency. I appreciate those concerns. I think the additional upside for them is that their non-bank competitors will have the same high standard that they need to meet, the same level playing field, the same consistent rules. So they don't have to worry. Community bank and a credit union doesn't have to worry about.
That kind of tells me that you're just broadening the uncertainty to include the entire financial markets. You're not.
No, I think what we're able to do, sir, with respect is to.
It seems to me the uncertainty is being broadened. That doesn't answer the question about uncertainty and that the banks are afraid of this kind of legislation.
I think what we're able to do is create a high, consistent, clear standard. We're able to reduce regulatory burden in many cases. For example, combining the TLN RESPA reforms that drive everybody crazy and don't help consumers. We need a single, uniform, simple standard for disclosure that applies.
I'd suggest that you need to convince the banks because they're the ones that are expressing the real concern. If I may, though, Mr. Barr, I do have a second question, and that is that President Obama has stated that a streamlined system will provide better oversight and will be less costly for regulated institutions. But the preemption statutes in the bill create a floor rather than a ceiling for state regulation. Doesn't that mean we're looking at 51 different versions of this thing by giving the preemption statutes to the state? And how does that not conflict with President Obama's statement that we're looking at a streamlined system?
Well, as you know, the states have long played an important role in consumer protection. I think one of the upsides of living in our country is that we have independent states that make independent judgments about.
They have not had preemptive status in this situation before.
They have not been able to apply state laws in some context to national banks. But they certainly have been very active in the consumer area across lots of different products and services in the past.
Do you think that could lead to 51 different versions of this throughout the state?
I think we're much more likely to see a high standard at the national level. I think it's very rare if you set a good high standard at the national level, you're going to find it very rare for states to go off in their own way. But sometimes states are right. Sometimes states protect consumers in innovative ways. And our view is we shouldn't block the state's ability to do what the states think and their judgment is right.
All right. Thank you, Mr. Chairman.
The Chair thanks the witnesses, and we want to thank you for, oh boy, no, we don't. The Chairman recognizes Dr. Gingrey for 7 minutes for the purposes of questioning.
Well, Mr. Chairman, thank you for your generosity of time. I'm sorry I missed the first round, and I appreciate you letting me ask some questions. And I did want to ask Secretary Barr, in your testimony, you indicated that we need only one agency charged with protecting consumers for financial products and services. As one of the principal architects of the administration's plan and the proposed Consumer Financial Protection Agency, you lay out a very broad and sweeping changes that will fundamentally change a number of government entities, of course, including the FTC. However, while this is still in the early stages, there are some concerns held by members, including me, that an overly broad new regulatory agency will have the same effect of hitting a nail with a sledgehammer. In these efforts, under the guise of uniformity, I feel that there may be some different standards set for industries within this proposed agencies. For example, I've heard that some suggestion that small banks should be exempt from some or all of the rules written by the proposed agency. And the drafted legislation contains exempted authority based on asset size. Is it the administration's plan to apply different consumer protections depending on whether a customer transacts with a small or a large bank? And furthermore, if you intend to carve out smaller institutions, what are the types of rules they would be exempted from, and what is the policy reason for carving out these institutions?
Thank you very much for that set of questions. I do think that our proposal does involve sweeping change. sweeping change that in our judgment is essential to protect consumers. Our old system was fundamentally broken, and we do need fundamental reform. With respect to smaller institutions, we don't expect to see, would not expect that small banks and big banks would have different rules of disclosure. But you may see differences in, say, how much examination or supervision there would be. In the bigger institutions, as we do today, on site, there are examiners on site year-round. You wouldn't want that for a small bank. So you may see differences like that, but not differences in the basic standards affecting consumers. Those would be uniform across the board. So if you walk into a bank, or you walk into a credit union, you walk into a big bank, or you go to your independent mortgage broker, or you go to an independent mortgage company, you get the same simple mortgage disclosure. So consumers can understand what they're getting.
Chairman Leibowitz, as you outlined in your testimony, there will be a number of changes to the FTC as a result of the Consumer Financial Protection Agency, if that becomes law. Many responsibilities will be pulled from the current jurisdiction of the FTC and be given to this new agency. And with all of these proposed changes, what then will be the role of the FTC in this new landscape, and how much of that new role will be duplicative of this proposed agency? You guys have been doing a good job. You know, we are appreciative of that.
And we appreciate, you know, and are heartened by what you said about our agency. I do think we do a good job, and we have terrific attorneys who really care about enforcing the mission of the agency, and good commissioners who are also committed. You know, we'll still have, let me just say, we still have all of our competition authority, right, our antitrust authority. We will continue to do all the other things we do, whether it's fraud or privacy outside of the financial context, or, you know, advertising and marketing practices. And then we'll continue to stay involved here, I think, especially during the transition period and hopefully beyond with concurrent jurisdiction. You know, look, there are, as we know in this room, and as you guys know better than anybody else, there are a lot of bad actors out there who are, you know, trying to rip off American consumers. And so, you know, by growing the federal ability to go after these malefactors, that can only help even the playing field, right? I mean, what we do at the FTC, and I think we do it really well, but it's a sort of triage, right? You know, we look at different cases, potential cases, and whereas we're going through an investigation, and we say, which one can we best leverage? Which are the ones that, you know, are the greatest harm to the greatest number of people? Which are the ones that might make better, change bad case law, for example? And we're always making decisions based on sort of the lack of resources that we have. We just try to do the best job.
Well, let me reclaim my time just for a second. I did want to ask you one other question. You look, we don't disagree with the need for oversight, but it seems to me that in this current financial crisis that we're in, and all of these bad loans and toxic assets and all of that, that the oversight got really heavy after the horse had already left the barn. Right. And so that's kind of a concern, and there's always the concern that the oversight it becomes too much, so restrictive after the fact that these institutions, particularly your small banks and lending institutions, can't function. And I certainly see this across my district in privately held banks, smaller banks, that the oversight should have been steady and consistent, and it always should be, but yet, you know, when some catastrophe occurs because somebody was not minding the store, then all of a sudden the oversight comes down on these institutions to the point that all of a sudden they go out of business. It hurts the local community. And but let me just ask you, in the little bit of time I've got left, you mentioned to us what the FTC would be able to continue to do. Mm-hmm. What percentage of what you currently do is that? Does that represent 50% of your current responsibilities, 25%? Are you losing more than 50% of what you currently are charged to do?
No. You know, I think it would be more like in terms of, if I think it through in terms of resources, I'll get back to you with I'll get back to you with a response, but I would say it is more like 5 to 10% of what we do, and of course it's been an area, as you know, that we've been concentrating on more and more because it's very important to American consumers, many of whom are suffering from many of whom, almost all of whom, are suffering from some.
Well, I would appreciate it if you would specifically get back to. I think it's important that we know that.
It is.
Mr. Chairman, thank you for your patience and generosity, and thank the witnesses.
The chair, again, the chair thanks the witnesses for the use of their time. You were very generous to us in terms of using your time, and we want to know that you have really contributed significantly to this process, and we are better off because you testified today and to help us move along on this new proposal. And so we will be in touch with you in the future, and the chair wants you to know that we will, there'll be, we will give members 72 hours to ask questions in writing, and if you will respond to them within a reasonable amount of time, the chair really would appreciate it. So thank you so very much.
Thank you. Thank you, Mr. Chairman.
Thank you. The chair now calls the second panel. The chair welcomes the second panel to the desk and to this hearing. The chair apologizes for the inconveniences that you might have had to endure while we were on the floor voting. And the chair is very respectful and appreciative of the fact that you've come from far and wide to be here to testify. I want to introduce our witnesses, and I'll begin on my left. Mrs. Gail Hildebrand is a senior attorney and a manager for the Financial Services Campaign for the Consumers Union. Seated next to her is Mr. Stephen Calkins, Esquire. He's the Associate Vice President for Academic Personnel and Professor of Law at Wayne State University. Next to him is Mr. Prentice Cox, who's an Associate Clinical Professor of Law at the University of Minnesota. And seated next to Mr. Cox is Ms. Rachel E. Barkow. And Ms. Barkow is a professor of law at New York University School of Law. And last but not least, the gentleman with the smiling face next to her is Mr. Chris Steinberg. And Mr. Steinberg is the president and CEO of American Financial Services Association. We want to thank you and welcome you to this committee hearing. It is the practice of this committee that we swear in witnesses, so would you please rise and raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? I do. Let the record reflect that all the witnesses respond in the affirmative. Now it is my privilege to allow you to recognize you 5 minutes for an opening statement. So, Ms. Hildebrand, we'll start with you.
Thank you.
Yeah,
Chairman,
turn the mic on and pull it close to you, please.
Thank you. Chairman Rush, Ranking Member Radonovich, and members of the committee,
You know Consumers Union as the nonprofit publisher of Consumer Reports, but our mission is to test, inform, protect, and empower consumers. And that's the role in which I appear before you today. My written testimony was joined by 6 national consumer organizations. Consumer groups want, and consumers in the U.S. need, a strong consumer financial protection agency, a robust Federal Trade Commission, and a strong role for states in consumer protection in financial services. We believe that those goals are entirely consistent with one another. The goal is a better financial services marketplace and better government in financial services oversight. We have to face it. The current system doesn't work. It's not delivering products or encouraging products that are understandable to consumers who use them or that meet the reasonable expectations created in the sales process. Instead, we have gotcha banking. We have multiple regulators by type of provider, even when those providers are competing directly for the very same consumer. We have long delays for regulatory action. And we don't have much of open public enforcement except by the FTC. And finally, we have abusive features in products that are squeezing their way through the holes in the existing law and the existing regulatory scheme. I believe the job of government is to serve the people. We're not here to talk about more government. We're here to talk about better government in financial services oversight. Today, our system just isn't designed to do the job. It's spread out over 6 or more agencies with a hodgepodge of rules and statutes. And how much enforcement a provider receives depends in part on who its regulator is. That is just not a system designed to match the realities of today's market. We want to give the federal government a different and new job in financial services marketplace, and that's to promote a fair as well as an efficient financial services market, to watch for the market to prevent harms as they start to develop. I come from the great state of California, where the option arm and some of the other products that have gone so terribly sideways were pioneered. And you can only wonder if someone had been watching those markets more closely, whether that would have spread around the country. The mandate of the CFPA is the right mandate, is to promote transparency, simplicity, fairness, with accountability and access. And notice I say promote. It's a different job from what the federal government has had before. And with the CFPA, we have the opportunity for an agency that has an obligation to get information, to learn about the market, to watch that market, and then to make a conscious decision about what needs to be regulated and what doesn't, and which regulatory tools to use, and then to apply those tools evenly no matter who's providing the product. With the CFPA, we could get one agency to watch over the market, faster acting responses, one agency that's responsible to you and to me when things go wrong, and one place for your constituents to go instead of the alphabet soup they have now of trying to figure out who to complain to and who to get relief from. The CFPA model is one federal rulemaker, but multiple enforcers. And that brings me to the incredibly important continuing role of the FTC. I'd like to disclose, Mr. Chairman, I was once a summer law intern at the Bureau of Competition at the FTC, longer ago than could possibly be relevant for today, but I want to disclose that. The FTC keeps its enforcement authority. It keeps its Section 5 authority with a simple, regardless of the topic, financial services or not, with a simple consultation that can be at the staff-to-staff level. It keeps its authority with respect to all the statutes it now has with that referral process. And I think it's very important to note that's a refer and wait process, but they're not waiting for a yes or no. If the CFPA does not take on a case the FTC thinks needs to be brought, it can still bring that case. The CFPA cannot say no. We have made a recommendation to you in the written testimony that the statute should allow the CFPA to waive that notice or to shorten it by individual case, by type or category of case, and by agency, so that they can work these things out where there's commonly, for example, the telemarketer case with the EFTA claim. And we also are recommending to you that the FTC be given the authority to be a secondary regulator with respect to enforcing the CFPA rules, not writing them, but enforcing them. The FTC does lose jurisdiction to write unfair and deceptive acts and practices rules in financial services, but that has not been a role they've been able to use widely in the last couple decades since the credit practices rule, which went into effect in the 80s. They keep all of their enforcement, and of course it will be made stronger with the aiding and abetting enforcement. We believe this is the only way to put all the competing products under the same set of rules. I have some examples, but I'll hold them for the Q&A because I'm conscious of your time. And I do want to say that I think it's very important what the FTC does right now in the recession. It's very important what the FTC will continue to do after the transfer of authority in those cases where there's overlapping enforcement, and it will be extremely important what the FTC does with its additional authority. There are a lot of things the FTC can do right now to help consumers who are suffering from the recession, including cleaning up the problem with credit reporting errors, the work it's now beginning to do under the new authority you gave it on mortgage modification and foreclosure, debt collection and debt settlement. All those things will remain extremely important. I'd be happy to take questions. Thank you.
Thank you very much. Mr. Calkins, you're recognized for 5 minutes.
Thank you. Chairman Rush, Ranking Member.
Would you pull the mic closer to you, please?
Yes, sir.
Thank you.
Is that all right?
Yes.
It's not on.
It's not on.
Push the button.
Push the button. Thank you. Special thanks for the technological advice here. Chairman Rush, Ranking Member Radonovich, members of the subcommittee, thank you for inviting me here to testify about this important matter. The proposed legislation would affect sweeping changes in the Federal Trade Commission. The key to the bill is in the definitions, and they are written extremely broadly. Applying those definitions and working your way through the bill, you find that the bill would transfer out of the Federal Trade Commission much of the work that the Federal Trade Commission now does, giving those responsibilities to the new agency and giving it the exclusive authority to prescribe rules and issue guidance with respect to much of what the Bureau of Consumer Protection does. If you take the FTC's most recent annual report for 2009 and turn to consumer protection and start reading what they have been doing, subprime credit, mortgage servicing, foreclosure rescue, fair lending, mortgage advertising, debt collection, payday lending, Operation Clean Sweep, Operation Telephony, the Synthesia marketing case, payment systems, the Neovi case, Nationwide Connections case, global marketing case, and so on and so forth, prepaid phone cards, on matter after matter after matter of what they have been doing, I read the bill as saying that all of that would be transferred to the new agency. In short, we would have major change. Indeed, if you read the bill carefully, you would find that even some of the antitrust responsibility of the Commission would be transferred. I assume that's a mistake, but that's how it is currently written. Now, why have this sweeping change in what the Federal Trade Commission does? It might make sense if the Federal Trade Commission was a bad agency that was doing bad work. But as you all have spoken so eloquently this morning, the Federal Trade Commission is a good agency that has been doing good work. It has a unique bipartisan structure. It combines consumer protection and competition to bring the best from both perspectives to bear on problems. And it has been doing important work for consumers, including in the world of credit, for a very, very long time. Transferring responsibility from the Federal Trade Commission to another agency obviously creates some pretty significant risks. And my recommendation to you is to proceed with great caution, to weigh those risks, to decide whether they're really worth running, and certainly if they are, to work very hard to try to minimize those risks, because the bill as written would make major changes, and you need to be very careful to make sure that all of this makes sense. Thanks very much, and I'm happy to answer questions when the time comes.
Thank you. Mr. Cox, you're recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member Radonovich. Oops. Thank you, Mr. Chairman and Ranking Member Radonovich. Abuses of consumer finance products were a disaster for millions of consumers before anyone recognized them because we had a financial crisis. A disaster. A previous testimony about someone committing suicide. I sat with people whose families committed suicide after I worked with them, who had heart attacks from the stress. Millions of people experienced this. Our federal regulatory system did not respond to this. It was dominated completely by the thinking and needs of the lenders and sellers, and not by what was happening on the ground. It is often said that no one could have seen this. The people who were working with the victims of subprime lending and were talking to people who reflected the experience of those people, as well as the others who were subject to the abuses of consumer finance products, absolutely knew what was going on and were screaming at the top of our lungs. No one was listening. It was predictable and it was preventable. The Consumer Finance Protection Agency, as proposed, offers the first hope in generations, certainly in my adult lifetime working on these issues, for an agency with sufficient power and focus on consumer protection issues to seriously address these problems. It gets it right in terms of its model. It sets up a unified rulemaking process. It's not about whether the FTC was good or bad. It's about the fragmentation of authority and the lack of perspective in a unified rulemaker. It gets it right in setting a floor and allowing innovation where innovation should occur, which is in the state regulatory system. And it couples that with an open enforcement system. It allows the enforcement of those clear, unified rules to occur in multiple places, and there are two reasons you want that. The first is that you can pair the proper enforcement agency, public enforcement agency, with the problem at hand. If you've got a problem that just occurs in Indiana, the Indiana Attorney General is the right place to do it. It simply won't get taken care of if you allow a federal agency. Conversely, if the Indiana Attorney General turns up a problem that appears to be nationwide, that can highlight the need for the agency. Secondly, the agencies like the FTC and state attorney generals often will bring violations of rules ancillary, which is what Chairman Leibowitz was saying, ancillary to other investigations because these things don't come up in little neat silos. So an open public enforcement model, which is what this bill has, by allowing the Federal Trade Commission and other federal agencies to enforce the rules and state attorney generals to enforce the rules, enhances enforcement. I will make two quick comments, one about the details of the enforcement mechanisms and the other about the rulemaking investigative authority. The open enforcement mechanisms in the bill are excellent. However, I agree completely with Chairman Leibowitz that the 120 days restrictions on the FTC is way too cumbersome. It needs to be streamlined and made more efficient. Secondly, and this is, I think, is a very important point, in the bill as currently constructed, the FTC is given the authority to enforce extant federal consumer credit laws, but not the regulations passed by the CFPA. The CFPA regulations over time will become much more important than the extant consumer credit regulations. It's really critical that the FTC get the authority to enforce the regulations that are passed by the CFPA. There's also a consulting power in there. Requirement, and that's correct, and I hope that on an informal basis, the agency takes account of the fact that the FTC, which enforces UDAP, Unfair and Deceptive Acts and Practices laws, gains a particular type of experience and understanding that's vital to setting those rules. Secondly, state AGs have authority, but that mechanisms for remedies need to be clarified because right now the Section 1055 powers, it's unclear whether those are bootstrapped into the AG enforcement. Finally, in its rulemaking authority, the new CFPA desperately needs detailed and express and clear investigatory powers. Otherwise, the data that is brought to bear and what the rules are will be data held by the industry that the CFPA simply doesn't have access to. So it's critical that the CFPA have that investigative power so that they can get the rules right the first time. I really appreciate the opportunity to be at this historic hearing and wish the Congress great luck in making this project work.
Thank you very much. Ms. Barkow.
Thank you, Mr. Chairman, Ranking Member Radonovich, and members of the subcommittee. Thank you for inviting me to testify before you today. I'm honored to have the opportunity to discuss this piece of legislation. The linchpin of the Consumer Financial Protection Agency Act is, of course, the agency it creates. So whether this act will succeed or fail in its mission to protect consumers will depend entirely on whether the agency it creates will succeed or fail. I've therefore analyzed the structure and powers of the proposed CFPA to determine if it has been designed in the most effective way to achieve its stated statutory mission. I take no position on the merits of that mission or whether there's a need for a new agency to regulate this field. Rather, my focus is on whether the CFPA has been designed as effectively as it can be to achieve that mission. In that regard, I'd like to make 6 brief suggestions and observations about the design of the CFPA in this legislation. My first recommendation, and the most important, is to add a provision to this act that would limit the CFPA board's membership to no more than 3 members of the same political party. Unlike virtually all other legislation that governs multi-member independent regulatory agencies, including the FTC, the SEC, and the Consumer Product Safety Commission, the CFPA Act, as it's currently written, does not require political balance among the agency's membership. There's a wealth of empirical studies that are demonstrating that a group comprised solely of ideologically like-minded people tends toward extreme decision-making. Without a provision in the CFPA Act requiring partisan balance, the CFPA is likely to change positions from one extreme to another with each new presidential administration. This is unhealthy for the regulation of any market, and certainly the consumer financial products market. A political balance requirement can serve as a stabilizing force. In addition, a political balance requirement can lead to dissenting opinions, which is valuable for alerting Congress and the public if the agency goes in extreme direction one way or the other. Second, I suggest amending the Act's requirement that the CFPA consult with all federal banking agencies and any other relevant agency before passing rules to make sure those rules will be consistent with the prudential, market, or systemic objectives of the agencies being consulted. Because this consultation requirement sweeps so broadly, covering every conceivable agency regulating related fields and anything of any importance to those agencies, this process is likely to dramatically delay the promulgation of CFPA rules. This is precisely the kind of requirement that aids industry participants in tying up agency rules for years. So unless Congress is of the view that the delay and legal uncertainty is outweighed by the benefits of this provision, I suggest making clear that consultation is at the discretion of the CFPA and not subject to judicial review. Third, I advise modifying the statute of limitations provision in the Act to begin running from the time the CFPA discovers a violation, not from the time a violation has occurred. Because violations by sophisticated business interests are not discovered for years in many cases, this provision as it's currently written might hamper the CFPA in its enforcement efforts. Fourth, I recommend including a limitation on the ability of CFPA board members to practice before the CFPA for a period of time after their service on the board has expired. This kind of restriction would limit the negative effects that are often caused by having a revolving door between agencies and the industries that they regulate. Fifth, I just would like to highlight a protection in the Act that I think is going to be critical to achieving the Act's law enforcement objectives. And that's Section 1042 of the Act, which allows the state attorneys general to enforce the provisions. State AGs have demonstrated in many areas that they can be effective law enforcement partners, and I think this is particularly true in the area of consumer protection, where agency capture is a significant risk. Finally, I'd like to alert the subcommittee's attention to the fact that it's unclear from this Act as it's currently written whether the CFPA will be subject to presidential directives and oversight, including review by the Office of Information and Regulatory Affairs, known as OIRA. There's language in the Act that suggests this is actually going to be an executive agency and will be subject to this kind of oversight. Congress may intend for the CFPA to be part of the President's oversight process, but if not, the Act would need to be rewritten to make clear that the CFPA is an independent regulatory agency for purposes of OIRA review. I take no position on whether or not the agency should be subject to this type of review, but because it's a fundamental question, I note for you that it's currently unclear in the legislation. Thank you again for allowing me to testify and share my thoughts on this proposed legislation, and I'd be happy to answer questions when we're all done speaking.
Mr. Steinberg.
Thank you, Mr. Chairman, and thank you for this opportunity to speak with you today. I'm very glad to hear that this is kind of a first step, and hopefully which will be a long process, because as many have expressed here today, there are certainly some concerns about this issue, and we hope that there will continue to be somewhat of a cautious approach as we go forward. The American Financial Services Association has been around for almost 100 years, and we represent about 30% of all consumer credit in the U.S., with members in the mortgage, credit card, auto, and personal installment loans. First and foremost, AFSA supports strong financial consumer protection regulation. Just because we have concerns going forward about the current agency does not mean that the industry and that the association is not committed to strong consumer protection regulation regarding financial services. We believe that consistent enforcement of existing consumer protection laws by government regulators would have greatly lessened the harmful impact that the current crisis has on consumers and certainly our economy. Many AFSA members are regulated primarily at the state level and subject to a patchwork of requirements. We firmly believe that consumer protections should be uniform in every state. Therefore, AFSA supports strong national consumer protection standards that allow the members to meet their consumer protection obligation in an efficient and cost-effective manner. In addition, strong national consumer protection standards will provide a benefit to consumers only to the extent that they are consistent with sound prudential regulation. Consumer protections that threaten the safety and soundness of financial service providers offers real no protection at all. We believe consumers will be better served by a regulatory structure where prudential and consumer protection regulations are housed within a single regulator. Congress tried to separate these two intertwining functions with the GSEs. When it became apparent that this situation was unavoidable, Congress brought the two regulatory functions back under a single regulator, and for good reason. We urge Congress to support regulatory structure that does not separate safety and soundness from consumer protection. The authority proposed to be vested in the new agency is breathtaking in both its scope and its effect. It would cover many entities and persons who have little or no involvement in the activities leading to the current economic crisis. Without any demonstrated need, many unsuspecting persons will be swept into a web of scrutiny and reporting requirements that yield little in the way of consumer protection, but much in the way of increased cost for consumers. Attorneys, accountants, consumer reporting agency, auto dealers, title companies, among others, will find themselves subject to review with no evidence that they behaved unfairly. Financial service providers will find it increasingly difficult to plan for risk, as virtually any practice or product other than prescribed standard plain vanilla products could be labeled as unfair or abusive. Innovation will be discouraged. Given the vast scope of the proposed agency's authority, its funding needs are also staggering. The proposal seeks to fund the CFPA by assessing fees on persons and entities it regulates, while including many that would not expect to be covered currently. There is no doubt that any assessment on financial service products will be passed on eventually to consumers. That direct, unavoidable result will be an increase in the cost and availability of credit. Most AFSA members are regulated by the FTC, which has a proven record of enhancing consumer protection. It has addressed the economic crisis in two ways. First, by using the enforcement authority to pursue bad actors in the financial services industry, and second, by setting federal policy through guidance and public comment. Numerous examples are listed in our written testimony. But in conclusion, AFSA believes that the FTC has done an excellent job in enforcing consumer protection laws and is best suited to continue that role going forward. We believe the administration's goal can be achieved with adjustments to the current regulatory structure, and the result will be more efficient, less costly, and certainly more effective. To that end, we have two specific suggestions. One, make current and future consumer protection rules apply to all financial services providers. Congress should ensure that all federal consumer protection laws and regulations apply with equal force to all providers of financial services with respect to similar cases of products and services. These laws should include strong national standards that preempt state laws and permit all Americans to enjoy consistent level of services and access with respect to financial products and services. We've heard again and again and again today, as you have 50 different states that can exceed or meet or exceed the current laws, this is not simplification. We're just going to wind up with 51, as you stated, Mr. Chairman, 51 different rules that these people are going to have to follow. And number two, pursue a regulatory structure that does not separate financial products and services from the viability of the companies that offer them. All prudential agencies should work together to coordinate consumer protection regulation for financial products and services, with the goal that regulations be preemptive, consistent, and uniform. If we don't have that, we're not going to make any headway. Thank you for your time.
The chair thanks the witnesses, and the chair now recognizes himself for 5 minutes for questioning. According to the administration's proposal, the states will be able to enforce the statutes and rules being transferred to the new agency right away. In contrast, the FTC will be required to provide the CFPA with notice of a proposed action, and as has been stated earlier, wait 120 days for the CFPA to determine if it would take the case before it take any action. This applies to the very rules and laws currently enforced by the FTC. Mr. Calkins, in your testimony, you suggest that this 4-month delay will prevent the FTC from ever investigating or taking action in these areas. Can you explain and expound upon that, please?
When I read the bill, I sat and tried to think about what life would be like under the new legislation and the 120-day rule. What would the FTC do? And as I thought about it and I read the bill, I read where the bill says, quote, all consumer financial protection functions of the Federal Trade Commission are transferred to the other agency. So who at the FTC is going to be doing the work to find that there is a violation that they wish to use the 120-day rule to develop? Maybe the FTC will go out and develop new resources to do this. Does that make sense? And I don't think that makes sense, because the whole point of the bill, it appears, is to transfer a large part of what the FTC does to this new agency. Let's talk about the 120-day rules. Well, we have experience with the FTC and the Department of Justice, where the FTC can ask the Justice Department to bring a civil penalty action for it, 45 days there. The reality is that the FTC, although I'm not sure they would admit it, goes out of its way to avoid using that authority. It is a lot more effective and efficient for the Commission to go directly to court, bring an action, take action against a wrongdoer, stop a fraud, stop some harm, get relief. And so they use the authority they can use by themselves. And time and again, they don't go to the Department of Justice. I think that that 120-day authority will be very rarely used in the new world. It's really there in case we have a new agency that is so opposed to enforcing these rules that an FTC might come along and try to develop some sort of alternative world as a backstop. But I think that the world that I see would have the FTC using this authority very, very rarely, and I just do not think that is the vision contemplated by the bill as written.
Does any other witness want to chime in here? Is this a shared skepticism on the part of the other witnesses? Ms. Barkow, do you are you skeptical of this backdrop rule?
It does seem like 120 days would be the equivalent of a lifetime in this kind of an industry where you're talking about the word
Well, if it was
assets disappearing.
if it was 60 days, would that make a real difference?
Well, that I leave to the FTC to decide, but the fact that they're worried about the 120 days, I think, speaks volumes about the fact that it's probably going to be a significant issue.
Anyone else want to chime in here on this?
Well, I think if you look at some of the discussion that occurred earlier, and they were talking about the number of days, but perhaps more importantly, look at the actual structure. They've taken so many of the personnel. The team has been taken from the FTC and is now part of the new agency. And yet they're supposed to maintain the backstop or the backup in these areas. But the team is gone. And as Mr. Calkins suggested, all they can do is go out and rehire new experts that are supposed to be the backup. It doesn't sound like a very good system to me.
Ms. Hildebrand?
Yes, thank you, Mr. Chairman. Under the one rule writing, many enforcers model, we want it to be as easy as possible for the FTC to bring the cases in its existing jurisdiction as well as to enforce the CFPA rules. If the Commission recommends a shorter time period, we would want you to look at that very seriously. We think a waiver process also could help there. The Commission and the CFPA could agree that for this kind of case, we don't need to know in advance, and for these other cases, we need a shorter period.
Okay, the Chair's time is concluded. The Chair recognizes the ranking member, Mr. Radonovich.
Thank you, Mr. Chairman. Mr. Calkins, the proposed legislation defines a covered entity to include those who provide tax planning, financial, and other related advisory services or provide educational courses and instruction materials to consumers. PBS often runs such programming on TV for their audiences, as do financial cable stations and radio stations. Would these entities be covered persons under the proposed legislation, in your opinion?
Certainly there is a risk that they would be covered persons. Certainly the Commission would have to think about whether it was required to transfer responsibility for all those. And then, very important, even if they are not covered entities today, the new agency has authority to define for itself additional activities that it would have jurisdiction over. Right. And so even if the FTC didn't have to transfer authority today, they might have to transfer authority a year from now when the definitions got changed.
Thank you, Mr. Calkins. Can you, I want you to comment on a prior statement about the FTC's bipartisanship and way it conducts its activities and how that's good. Can you elaborate on that and how the lack of bipartisanship might hinder the CFPA's ability to effectively carry out what is now the FTC's mission?
Well, the FTC, I think, has, over the years, developed credibility with Congress, with the states, with international observers, because it operates in a bipartisan way. The commissioners try to work by consensus. They try to take the actions that make the most sense. When somebody wants to go out on a limb and be really wild and crazy to the left or the right, there's someone from the other side to pull them back in. As noted before, Ms. Barkow, when you have people going too far, dissents can be filed. And it succeeds in developing a shared understanding of the sensible way to proceed. And then, as presidents come and go, there exists some continuity. And that continuity, I think, adds credibility to the agency's operations and really has made it into a more effective agency.
All right, thank you. Ms. Barkow, would you care to respond to that question as well?
I agree completely, and I think that the whole idea of an independent regulatory agency, which I think is part of the goal in this legislation, is to have that kind of consensus-generating form of norms that transcend any particular presidential administration, so that you don't have the instability that comes with every new presidential administration means sweeping changes one way or the other. You have a stabilizing force in an agency that has membership from both parties. I think it's proven to be effective in other contexts, and it's hard to understand why you would have a multi-member agency here that doesn't have that mix of political views on it. I mean, why not just then have a single member board?
Thank you very much. Mr. Steinberg, I want to ask you about uncertainty in the financial markets, this massive shift of responsibility and the creation of the new agency on consumer protections. Your bird's eye view on the industry, how it would react to something like this, and the level of uncertainty that it might bring into the markets where uncertainty is we're trying to do everything to avoid uncertainty. Would you comment on that, please?
Well, some might argue that this is the perfect time to do something like this. I think it's absolutely the worst time. We're finally starting to see some stability in the financial markets. We're starting to see some recovery. We're starting to see investors come back into the marketplace, which eventually investors have to buy these loans out there. In Europe and the U.S., we're starting to see movement back in there. This does introduce a whole level of uncertainty back into the whole arena, because people are now going to stand back and wait and see what goes on, whether there is additional liabilities, requirements, and regulations on these entities. Right. So yes, I do agree that it's going to bring a new level of uncertainty into the marketplace at the worst possible time for that.
Can you describe a scenario where the duplicative regulatory authorities allowed by this Act's weak preemption provision might actually prevent consumers from access to to valuable financial services? This is the state preemption issue where you'd have 51 different.
Right now, it's set up as basically a floor or a standard that states will have the ability to exceed. Someone will make a judgment whether what the state is trying to do is meeting or exceeding. I'm assuming that would be the new agency. Mm-hmm. But if a determination is made by then that it exceeds it, of course, anything that they would do to exceed would be permitted. So I think you've seen it in many other instances. I'll give you the most recent, the new SAFE Act. That was the licensing for residential mortgage originators. You basically have out there in the implementation of that law 50 different standards that everyone's trying to meet, and each of them, many of them, exceeding the federal guidelines. So people that are regulated at the state level or have to register in multiple states as originators are going to have to follow very, very many different laws.
All right. Thank you very much. Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Massachusetts, Mr. Sarbanes. Maryland, I'm sorry. Oh, boy. Maryland.
We're trying to get to Massachusetts. Yeah. We got one Republican left. Okay. Thank you, Mr. Chairman. I appreciate the hearing. Mm-hmm. Mr. Steinberg, you said this is absolutely the wrong time. What would be a good time?
Well, I think when you go back, and there's plenty of history to point fingers at what was the cause of the subprime mortgage crisis and the currently economic crisis, but I don't think you'd get anybody that would predict that whatever is done here today, or even by Congress, that you can control every bubble that is going to occur in the future. Most economists would agree that, yes, this bubble was a housing bubble. Before it was a tech bubble. Before that, it was a savings and loan bubble. You cannot have government totally controlling financial markets unless they can totally control potential bubbles, unless you totally stymie innovation and all you have is a plain vanilla, standard product out there. And I don't think that's good for the very consumers that we're trying to protect here.
I agree with that. I mean, I don't think you can have government totally controlling every single financial dimension in the market. Don't think you can do that. I don't think this tries to do that. I think what this tries to do is provide some oversight and direction and rules of the road so that people stop driving off the road. Not only because, in the view of Alan Greenspan, that causes the drivers to crash and hurt themselves, but because they run over hundreds of thousands of innocent bystanders in the process. Let me switch back to a discussion from a few minutes ago, because I think it's very relevant. As attractive as the new agency may be to some, and I'm partial to it as it's being described, we still have to get from here to there. And I worry a lot because even if we had in place now the regulatory structure that we thought was necessary, it would have to be in overdrive, I would argue, to be on the lookout against predatory action that's lurking out there. But certainly in a transitional phase, predators have a lot of opportunities to make mischief. And I think the discussion about the 120 days kind of points to some of this anxiety. But I'd like anyone who would care to, I'd like to hear you respond to the idea of some kind of a special initiative or task force or consciousness that during this transition, we need to be paying attention to, maybe it's a limited set of activities or potential mischief, but that there's got to be a special focus on that so that we don't make the transition saying, now we got a good regulatory structure in place. But in the meantime, while that happened, a lot more people got hurt. And I say this because there's a lot of money that is flowing right now, taxpayer money, into the financial infrastructure of the country. And many of the same players that took advantage of people over the last few years are thinking creatively of ways to take advantage of them again by accessing some of these dollars. So speak to that issue of how we can not be caught napping during the transition. We can start with you, Ms. Hillebrand.
Thank you. I believe you're asking exactly the right question. There will be a danger period during the transition. There are a couple of things, and I don't have the whole answer. One is the work that the FTC does right now and continues to do up to that date of the transfer of rulemaking authority will be incredibly important. It could be up to 2 years after enactment. If these two titles are enacted together, the FTC will get its rulemaking improvements right away and can get some of these rules that have been kind of backlogged because of the limitations on its power moving and into place. That will help, certainly, to put those policing into place. We do need to be paying attention to the new problems that will be developing. One that worries me in particular is a new form of zombie debt. You know, that's the debt where no one's got the paperwork. Someone just has a list saying you owe this amount that might come out of some of these mortgage unsuccessful modifications or post kind of mortgage dispositions. So there are new issues, a lot of old issues. The more we can get the FTC to do now before the transfer, I think the better shape it will be in. But we will have to watch for that, yes. And the other thing is there's not going to be enough enforcement resources. Moving people from where they are over from all the different agencies is not going to give us enough enforcement staff to do the whole job for the country. The FTC has worked very hard. They said they had 100 cases over 5 years. If you talk to any state AG in the country, they'll tell you 100 cases, we could bring that in my state tomorrow. There's more need than the number of people that are currently in place to do consumer protection, enforcement, and financial services at the federal level.
Yes, sir.
I think you need to break your question, which is a great question, into two parts. One part is more scam-like activities, and I think this Congress effectively delegated to the FTC charge to go after foreclosure rescue scams, where a lot of mortgage brokers are moving in, and loan modification scams and that kind of thing. That kind of activity, the existing authority clearly is sufficient to regulate, and the additional authority has recently given help. You break that from more traditional and large-scale sale of products such as mortgages, et cetera. And I think in that area, the credit markets are so beaten down that I think that this agency would be up and running effectively to get ahead of the new products that would be.
That's helpful. That's helpful. Okay. Thank you very much.
The chair will extend to the members an additional time for one additional question, and the chair recognizes himself for one additional question. I want to get back to this area of concurrent enforcement, and are there any risks or downsides to consumers or industry with this whole idea of concurrent enforcement between two agencies? I mean, can you predict or look into a crystal ball and tell us what you see in terms of downsides or harms to the industry or to consumers regarding this whole area of concurrent enforcement? Anybody want to jump in? Mr. Steinberg?
Well, I'll give it a try to go first. One of the whole things that I think the agency being proposed is supposed to do is have single source responsibility. Then you take enforcement and you break that among current enforcement agencies, and then you have a new agency that's supposed to share some type of dual enforcement. It doesn't sound practical to me. We think that enforcement should continue to stay with the existing agencies. Now, to your question, Congressman, about the timing, and you mentioned the speed limit and people watching the people going down the road. I think that I don't think anybody would deny that the regulations or the speed limits were in place, but up until several years ago, that perhaps the regulations were in place, but the enforcement and the oversight was not. But I think if you look today in all of these agencies, whether it be the FTC or the other agencies in Washington, I think everybody has their radar guns out and are certainly looking at consumer protection issues as well as credit and lending issues in general. I don't think there's ever been a focus in this area like there is today. And so to that respect, I think that going back to your question, Mr. Chairman, I think that it's very important, I think most important, that there be continued responsibility between safety and soundness and the viability of those companies and consumer protection. And I think it is unwise to separate those two entirely. I mean, we have gone through a good example with the GSEs of trying to do that and finding out why that doesn't work. And it would be very simple if that agency that is just concerned about consumer protection can make everything so safe that it's not really good for the companies offering those products or for the consumers themselves. There's always going to be risk in this industry that defines what it is. And I don't think you can eliminate that entirely.
I think it's a really good question, and I would say that I think it's not so much of a risk as long as the rules of the game are clear. So long as you have the one agency that's setting the rules and what it is that companies have to do, the fact that there would be multiple enforcers of those rules is less disconcerting because you'd have clear standards and everyone would know what they are, and you would essentially have this kind of more cops on the beat analogy. And so that's why you could have state AGs helping out, you could have the FTC helping out, you would just be getting more manpower, but the rules would be clear. So really the success of it would depend upon what kind of rules end up being produced from this process. And I guess I would just say that's why it works to have, for example, all the states can police Medicaid fraud, for example, and it's not a risk because everybody knows what they're looking for. And so it would just be it'd be really important for the agency that's created to have clear rules. And if they see an enforcement action that looks like it's not really in the spirit of those rules, the act as it's written, for example, if the state AG brings it, the CFPA could intervene and they could step into that action and make clear that that's a bad interpretation of their rule or it's a bad enforcement action. So I think it's okay to have multiple law enforcers, and in fact probably necessary because there just aren't enough resources for all the fraud that's out there.
Ms. Hildebrand.
Thank you, Mr. Chairman. I had to think for a moment about your question to remember that there already are 6 concurrent enforcing authorities. It's just that the banking agencies haven't used that open public enforcement model to bring cases with the vigor and approach that the FTC has used. So we already do have concurrent enforcement, and the downside has been that many of the agencies, other than the FTC, that have enforcement authorities also have other obligations that tie them very close to the industry that they regulate. We'll, at least with the concurrent enforcement authority with the CFPA and the FTC, we won't have that problem, and I think that's a good step forward.
Mr. Colgan?
Mr. Chairman, I think that concurrent enforcement authority could work if done carefully, but I worry that there's too much attention to the FTC as an enforcer. I prepared for this over the weekend when the website was down, so I was reduced to the documents that I happened already to own. I owned a 2004 annual report. It happened to be in my files. I opened it up to Consumer Protection, where the FTC has a good list of the range of activities in which the agency engages, and that is part of what makes it a success. Consumer protection policy: 1, research and reports; 2, hearings and workshops; 3, advocacy; 4, amicus briefs; 5, consumer and business education and outreach. The FTC is not just a cop on the beat. It is an agency that has economists, that does competition, that does consumer protection, and uses a whole range of tools to develop expertise, to identify problems, and to craft solutions. And if a huge part of what the FTC does as a matter of subject matter is transferred out, and if the new agency has the exclusive authority to give guidance in this way, then we've lost a very great deal of what the FTC does, and I think that the consumers would be the worse for it.
Mr. Cox.
Chairman Rush, I think ultimately the industry will make two arguments about the current authority and the problems with it. The first is it's too much of enforcement, but as Ms. Hildebrand said, and as someone who spent years making priority lists, your list is way longer than you'll ever get to, and the problem with this bubble certainly wasn't bursting, was not too much enforcement. The second problem, which is more subtle or real, is an inconsistency in enforcement policy. And Ms. Barco appropriately says that this rulemaking authority, if it's clear, if the rules are clear enough, certainly will solve the problem. And I would further say with that, the CFPA is given the sufficient authority to make sure the enforcement is happening in a uniform way. But there's a second response to the inconsistency, which is unlike rulemaking, where I agree you want a unified rulemaker. When it comes to enforcement, this is where regulatory competition actually works, because you're competing to be a better enforcer as opposed to competing for a race to the bottom so that people will charter with you, which was a serious problem in creating this situation. And when you compete to do better, you are aware that if you don't do it and somebody else enforces your rule in a situation that you might get embarrassed, Madoff, SEC, you know, that when you have competitive enforcement, you have a market that essentially forces public entities to be aware of that. That actually works. And when it comes to UDAP authority, I just want to say, it's so important. The state attorneys general, and I'm patting myself on the back here because I was part of a small group who did this, we were the only ones out there screaming about and bringing these cases. The FTC was saying, and it's great because they were going after different actors, but we did one case where we got $500 million back to people with subprime mortgages, household, followed by another case where there was $300 million, and I thought that was too little, and I'd left by then, and I was the hog. So, I mean, this was a problem that if you were on the ground, you saw it. I mean, it was visceral. It was, these people are utterly out of control. The state AGs were able to enforce it because they had a different enforcement agenda. They were sitting at a different place. Regulatory competition works in terms of an open enforcement model.
Chair, now recognizes Mr. Radonovich for one question.
Thanks, Mr. Chairman. I appreciate everybody's testimony, but Mr. Cox, what I thought I heard was that we need multiple agencies having to do the same job to make sure that the people are doing their job, and that to me is a recipe for wasted spending. But I do want to ask you a question about I believe it was Ms. Sutton who was here earlier, talked about a situation where an 84-year-old woman who owned her place free and clear was duped into a 30-year mortgage. I'd like to know whether or not there was family involved putting her up to that, and that happened for reasons that wouldn't have anything to do with this current financial crisis, but I happen to represent Stanislaus County in California. It's the epicenter of mortgages, frequently the #1 county in the nation where mortgage defaults and foreclosures have happened. So I have a great appreciation for what's happening here. And you'd hear tales about One in particular, non-English speaking people that were talked into a home that all they needed to do was come in and sign the papers. Once they got there, they were jammed with points and fees that they knew absolutely nothing about, and were put into an uncomfortable situation, signed the mortgage papers, later lost the house. So I'm curious to know, after we have spent, in reaction to this financial crisis, anywhere between $800 to $1.5 trillion to stimulate the economy. We get no rise, we get a rise in the unemployment rate that we're supposed to drop. With all that spending, I'm a little leery of broad sweeping reactions to the problems that we're in. So how does something like this, and I'd offer that to you, Mr. Cox and Mr. Steinberg, and anybody else that wants to respond to this thing, how would that help the person? I'm not sure about the Sutton case and that. I want to know whether the family put them up to that poor, unfortunate elderly person up to that situation. But my situation in Modesto, California, where the non-English speaking person was jammed into that loans and the shyster put points on there, and then they quickly sold the mortgage to somebody else, and this guy was washing his hands and he was out of there. How does this broad sweeping change that you're talking about prevent something like that from happening? And at what cost? Any more so than what is currently on the books to prevent?
Thank you, Ranking Member Radonovich. I will respond to that by also responding to Mr. Steinberg's earlier comment, that we all agree that the regulation was there, it was an enforcement problem. We don't all agree on that. And here's, the problem had two parts to it, if you want to break it into its grossest problem. The first part was the type of products that were being sold. They were simply way too high risk, way too complex, and way too aggressively sold for average consumers to work through all the problems and understand all the costs and consequences in the context of these mortgages. For instance, the great held up at the time as the great financial innovation, the payment option arm. It was sold so aggressively on its benefits, but its risks were not clear to the average consumer, to my aunt. It was the kind of thing I could have sold her on if I was an evil person without informing her of the risk. So there's a product regulation problem that existed here. The Fed, if you read the Fed's papers during this time and you put them right next to the industry's papers, you could change the titles. You couldn't tell the difference. There was one type of thinking. That needs to change. The second problem was a fraud problem. The fraud problem got so far out of control. I've never seen anything like it. If you were at the level, you were talking to the people and you saw what's going on, if you talked to the ex-workers in these agencies, et cetera, and these companies that were selling these things, fraud was so rampant in this industry that, that was almost a separate problem from the product regulation problem. And so we also had a lack of enforcement, particularly at the federal level, on that, on fraud, but we fundamentally had a product regulation problem. I hope that responds.
Mr. Stein.
Commenting back to Mr. Cox's earlier discussion about whether we should have multiple regulators is a good thing. I ask you, if you're a business and you have multiple regulators and 2 and 3 regulators, is competition really good if you're the regulated entity and the costs that are involved in that? I mean, so the FTC is in your office one week and asking and having your staff gather everything else, and the next week, another regulator's in there. I can see where there might be some contention where that is good, but you won't have businesses that anyone that operates a business, small profit or a large business, which think of having multiple regulators and enforcers coming into your offices is necessarily a good thing, because and all of those costs are eventually passed on to consumers. These do not happen in vacuums. So yes, there are protections, I think, that need to be in place, and you're absolutely right about that. But I do think you can overdo a process too. We want to have a process that protects consumers but is efficient for everyone involved, that it's efficient for the safety and soundness and the viability of the companies that are being regulated, as well as good for the consumers that are buying their products. And I think that that's an important thing.
I'll just say thank you.
What's that?
Thank you, Mr. Chairman.
Yeah.
He's asking for
the chair recognizes the chairman emeritus, Mr. Dingell.
Chairman, I thank you for your courtesy. This question to Gail Hillebrand and to Professor Calkins. What authority will remain in the FTC to protect the consumers after the administration's plan has been adopted, if it's adopted in its current form?
Thank you, Chairman Emeritus. The FTC retains all of its authority to bring Section 5 enforcement, subject only to a staff-level consultation, coordination, and discussion.
So it would lose that authority?
The FTC retains that authority. I'm going to give you a list of things it retains.
Okay.
It retains its Section 5 authority. It retains its authority to bring cases under the statutes and rules for the enumerated consumer statutes. That's our alphabet soup: ECOA, EFTA, Reg Z, and so on. It retains, well, those are big things that it retains. It also retains its pure fraud authority. I mean, there are financial services, and then there are people who tell lies, who say, sign up with me and give me your Social Security number and your checking account number, and you'll never see me again. It retains that authority. Those folks are not selling financial services. They're selling lies. It retains that authority. And we have recommended that it also be given the same kind of backstop authority that it now has currently and would have under this proposal for the existing consumer statutes with respect to enforcement of the CFPA rules. That is not yet in the proposal.
Now, what would it lose? What would FTC lose? What consumer protection jurisdiction would it lose?
Yes, the FTC would lose a jurisdiction that has been difficult for it to use, which is its important but difficult for it to use, which is its authority to develop unfair and deceptive acts and practices rules in the financial services area. I'm sure you're aware the last time that authority was used was in the credit practices rule, which came into effect in the mid-1980s.
Okay, now why should that be taken away from FTC?
If we were looking at just the FTC, there'd be no reason to take it away. But the problem is we need...
All right, there's no reason to take it away.
No, I'm not quite
now
finished.
Let's just go a wee bit further and explain to me why we should give it to some of those good-hearted folk who led the fight for the repeal of Glass-Steagall, who deregulated banking and financial services, and who left us this glorious mess, which we now have in the form of probably the biggest depression that this country has had since 1929. Now, why should we do that?
We need to give that authority to an agency that can make one set of rules that applies to the bank provider and the non-bank provider. If the
I have no objection to taking care of the bank regulatory agencies. Let them create them and let them do their thing. But why wouldn't we want the honest men and women at FTC looking over their shoulder, and why wouldn't we want them looking over the shoulder of those good-hearted banks and financial folks and MBAs up in New York that created this mess? Now help me. Why wouldn't we want that?
We definitely want oversight. We want somebody who can look over no matter
what kind of... Do you like the idea of
having
the FTC sort of keeping an eye on those people?
We like the idea of having an agency that can look at everybody, not just the non-bank providers, keep an eye. And we think the best way to do that is to put it all in one place. What about the
good-hearted banks that are going to be engaging in all kinds of things? They're going to be engaging in real estate. They're going to be engaging in issuing of bonds and securities. They're going to be engaged in all kinds of wonderful activities on derivatives, which are really gambling devices. So why shouldn't the FTC retain its continuing and ancient jurisdiction over keeping honest men honest and maybe occasionally catching a rascal? Now, why should we take that away from the FTC?
Mr. Chairman Emeritus, I respectfully suggest
you represent consumers. Why shouldn't we just leave FTC as it is and let these other folk go about their nefarious business under the kind of weak-minded regulation that the Treasury has traditionally given to these institutions.
We're absolutely in favor
Now, give me a good reason
of
for that. You're speaking here for the consumers, and I'm trying to figure out, do you really understand the consumer's needs, or are you engaged in perhaps disregarding the consumers because these other folks have done a better job of telling you what a wonderful job they're going to do after they have brought about not one but two depressions?
I'm looking at it from the point of view of the ordinary person who's trying to get a mortgage. And they want to know, I mean, the consumer doesn't think it's TILA, RESPA, it's sales practices, but there's no federal rule on that.
But it's to the wrong question. Answer my question, please.
The answer is we think
why should we not keep FTC in its traditional jurisdiction of protecting consumers? When I was a boy, Roosevelt tried to give FTC jurisdiction over the stock market. And you can't imagine the outrage that this generated in New York because they were scared to death of the Federal Trade Commission, which is under jurisdiction of this committee. We keep them honest. And we find that as soon as the SEC got away from this committee, they all of a sudden became a wholly owned subsidiary of the securities industry and the banking industry. Now, why should we sanctify that by stripping the consumers of the one remaining protection which they have, the FTC, in favor of giving it to a congregation of folks well known to be influenced by some of the worst scoundrels in our society?
Are you ready for my answer? We believe that we need to put it in one place so that the non-banks aren't saying, oh, don't regulate us because the banks can still do that. And the banks aren't saying, oh, don't regulate us because the other guy can still do it.
We don't mind having this agency that would be created by the administration's proposal do that. What we want is to have the FTC there so as to sort of watch over these people and let them know that there are honest men and women watching them so that the rascality is diminished and the consumers are protected. What's wrong with that?
I think we have the same goal and perhaps a difference of perspective about how to get there. We think it will be difficult to get there without having one agency.
Are you telling me that you like the idea of having the FTC continue its jurisdiction while these other good-hearted folk go about their nefarious business?
We have endorsed full retention of FTC enforcement authority, but we think you've got to put all the rules in one place.
We have talked about what FTC is going to lose, and you are apparently advocating the losing of it. I am not of a view that maybe we want FTC to lose that jurisdiction, and maybe we want FTC to be around to sort of provide a minor dampening of the rascality which is going to continue to occur in the financial services industry. Now, what is your objection to that?
We believe that if you need to put the rules...
In just a few words, what is your objection?
Put the rulemaking in one place so that it's very clear whose job it is, and then you can hold them accountable to do it.
They arranged that one-stop shopping when they moved this whole thing across the hall. And since then, the whole financial services industry of the United States has had to be bailed out to the amount of $700 billion, which was congregated by Mr. Paulson, who came from that industry, and which has done nothing but enrich the same rascals that caused the trouble. And it has not only enriched those rascals, but it has given us something new to think about, and that is it has seen to it that they've had the funds to pay the same scoundrels who made the mess enormous bonuses amounting to as much as $165 million in one instance. Obviously, this is the product of one-stop shopping, which I suspect you are telling me you support, or maybe you want to tell me now you don't support.
We're trying to end the ability to shop for your regulator by having one entity write the rules, no matter what kind of charter or what kind of provider. That's our position.
Well, have to say I think somebody else wrote your statement, but I thank you for your presence, and Mr. Chairman, I thank you for your courage and ability in bringing this event about. Thank you.
The chair thanks the chairman emeritus. The chair thanks the witnesses. This hearing is now stands adjourned. But before we adjourn, I really wanted to let you know how grateful we are for you to extend your time with us and spend your time with us. By unanimous consent, I request that members submit all questions to be sent to the witnesses for the record within 7 calendar days, and the witnesses will respond promptly to the questions that are submitted to them. Thank you so very much, and safe travel.